On today's vlog, should Cookie Monster steal the cookie? Viva Frei, Montreal litigator turned YouTuber, and this is Pudge. She doesn't get much airtime because she's paralyzed in the back legs and doesn't have full mobility around the house, but this is Pudge. Say hi, Pudge. Hello, everybody. Nice to meet you. Mwah. Alright, what on earth is going on? Because this video is not about Cookie Monster or stealing a cookie. I just did a live stream with Jurg Sprava from the Slingshot channel, and we talked about the movement to unionize or create a YouTuber's union. And a union not in the formal labor union type sense, but more in the movement type sense, as in to get a collective to force YouTube to be a little more transparent in terms of demonetization, the rules, the algorithm, etc., etc. In the context of that live stream, which I will link right here, Jurg talked about something that I was largely unaware of, as in there is actual demonetization where you get the little yellow icon, and then there is sort of informal demonetization where even if you have the green icon, YouTube may or may not promote your video based on the content, based on certain terms used in the video. Now, it seems to be common knowledge among the internet that if you criticize in a video, it will get demonetized, as was my video up until about 20,000 views. And in that video, if you haven't seen it, give it a watch, it's a good one. A lot of people are asking the question, can sue? And so as not to trigger the algorithm to demonetize this video, just bear in mind that whenever I say Cookie Monster, I mean, and whenever I say steal, I mean, and whenever I say cookie, I mean, and I'm just joking, I really don't care. I can't possibly do an entire video like this. One of the questions a lot of people were asking in the comments section of my video talking about Abraham Lincoln's expression and its application to journalism, more particularly the recent article that was written about Brett Kavanaugh and about how apparently 30 some odd years ago at a Yale party, he apparently did something obscene to somebody. The problem with that article is that it was missing one minor detail, that the alleged victim refused to go on record and that apparently, according to her friends, she didn't actually remember the alleged incident. Details. And so I did a vlog breaking that down, and a lot of people were asking, can Brett Kavanaugh sue the New York Times for defamation? And so I figured that would make for another good vlog. Now bear in mind, when we are using the term can someone sue, we are not saying physically can someone sue, because people can always sue for whatever the reason. They don't have to have a good reason to sue, so they can sue. The question is it a legitimate lawsuit? Is there a legitimate basis for a lawsuit for defamation against the New York Times by Brett Kavanaugh as a result of what many believe to be a highly slanderous hit piece? I hear some noise. I see someone directly in my line of vision. You can't see her, but I see her. She's coming into the frame in 3, 2, 1. There she is!
Who are you talking to?
The world. Oh, that's leftover. When you become a parent, all you eat is leftover kid food. It's wonderful. Leftover uneaten egg that children don't want to eat. Alright, so can Brett Kavanaugh sue the New York Times for defamation for that article and the correction that they ran the next day? The answer is yes, he can. In the physical sense, he can sue them. Does he have a legitimate legal basis for the lawsuit? Well, according to Judge Napolitano or Napoliano? Well, according to Judge Napolitano, if you are inclined to put any weight into his professional opinion, he believes that Brett Kavanaugh does, in fact, have a legal basis for a defamation lawsuit against the New York Times. But let's back up to the beginning here and deal with one thing at a time. Defamation, what is it? I've done a few videos on it, but in a nutshell, defamation is making a statement that is false that damages somebody's reputation. If those three elements occur, then one can sue the other party for defamation. They have to prove that the statement is false. They have to prove that the statement caused damages. Now, in one of my previous videos, I mentioned that Quebec is kind of a unique province, and in Quebec, one can actually succeed on a defamation claim even if the allegations are in fact true, but if they were made with the intent to harm the individual against whom they were made. And a lot of people in the comment section were understandably flipping out and unfortunately bashing Quebec for being one heck of a bizarre province. I don't make the law, I only discuss it. But for those of you who are shocked at that possibility under Quebec law, bear in mind that even in the United States, there is something known as public disclosure of a private fact, which can serve as the basis for a lawsuit in damages, and which is exactly what it sounds like. Public disclosure of a private fact. That private fact may be true, but if it is disclosed to the public with no reasonable justification, the individual whose private fact was so publicly disclosed can sue for damages. That is sort of similar to the idea of succeeding on a claim for defamation, even if the statements are in fact true. Similar but not identical, I recognize that, but that is just to water down the argument that it is absurd that in Quebec, defamation can occur even if the statements are true. Now, there is a well-known exception, or rather a higher threshold to succeeding on a claim for defamation in Canada and in the US as relates to public officials, public figures, and the press in general. The threshold for succeeding on a claim of defamation for a public official or a public figure is much higher than that for a private figure. The idea being that they already live in the public limelight and therefore are subject to more scrutiny than, say, private individuals. And when it comes to the press, there is an even higher threshold for succeeding on a claim of defamation because of the thing we call freedom of the press. It is a widely accepted principle that a free press is the cornerstone of a free society. The press needs to be free to investigate, to publish. The press needs to have the freedom to report on public figures, public officials, even if at times they get it wrong. And if the press were to be held to the same standard as private citizens, if they were to be held liable for every time they made a public false statement, especially about a public figure or a public official, there would be a chilling effect on the freedom of the press and one of the most fundamental principles of a free and democratic society. And in the United States, the freedom of the press is even more primordial than it is in, say, Canada or the United Kingdom. It is among the holiest of holies as far as freedoms go in the United States. So when public officials or public figures sue the press for defamation, the threshold is even higher and was established by the Supreme Court as being one of proving actual malice of the press for having published the story. And this goes back to the Supreme Court decision of the New York Times versus Sullivan, where 6 of the 9 Supreme Court justices concluded that in order for a public official to succeed on a claim of defamation against the press, they have to prove actual malice of the press. And what does actual malice mean? And in that Supreme Court decision, the court defined actual malice as having made a statement knowing that it was false or with reckless disregard for whether or not it was in fact false. And in further Supreme Court decisions, the courts elaborated on this principle of actual malice and acknowledged that it's a subjective principle, meaning that one has to prove that the entity that made the statement subjectively in their mind of minds knew that it was false or had reckless disregard for whether or not it was in fact false. And what is the burden of proof? When the plaintiff to a defamation lawsuit against the press is a public figure or public official, they have to provide clear and convincing evidence that the statements were made with actual malice. And just to open up a small parenthesis to answer a question you might be asking yourself right now, for a private citizen to succeed on a claim, they need not prove actual malice to succeed on a claim for compensatory damages, but they do need to prove actual malice to succeed on a claim for punitive damages. Parentheses closed. So bringing this all back to the original question, should Cookie Monster steal the cookie? I'm joking. Does Brett Kavanaugh have a legitimate claim for defamation against the New York Times? Again, all of these questions are always fact-based. It depends on the facts. It depends on the details, and above all else, it depends on the evidence that can be made. Brett Kavanaugh would have to prove that the New York Times acted with actual malice in running the original story without the detail that they added the next day, a detail which, as far as I am concerned, is not a detail to add specificity to the article, but is rather a detail that would have justified the New York Times not running the article in the first place. And there is a good argument to be made in that the New York Times, even by their own admission, had written the article based on an adaptation of a book. And the detail that was omitted from the original article, namely that the alleged victim didn't want to go on the record and that according to her friends, she couldn't recall the incident having ever occurred, that is no small detail to omit from the original article. So the question is, why was that detail omitted? Was it omitted by accident or was it omitted on purpose? Was it omitted with the specific intent to not undermine the salacious allegations made in the original article? Because had they included that detail, it certainly would have undermined the article itself and maybe caused a lot of people to question why they were running that article in the first place, given the undetermined nature of certain essential elements of the article. And like I've said in many vlogs in the past, sometimes the question is not do you have a legitimate basis to file a lawsuit, but even if you do, ought you do it in the first place? And as relates to Brett Kavanaugh, who is now a sitting justice of the Supreme Court of the United States, the question is not only going to be one of optics, what's it going to look like if a Supreme Court justice is suing the New York Times for defamation? The question is also going to be one of logistics. What happens when a Supreme Court justice sues the press for defamation? All the things that happen in a lawsuit are going to happen. Brett Kavanaugh is going to have to sit down for deposition, and that deposition probably is going to be leaked to the media like all other depositions. Brett Kavanaugh is going to have to answer a myriad of questions. Incidentally, it wouldn't be much different than the confirmation hearings, except given the fact that there were hours of confirmation hearings, now he's going to have to sit down for a deposition, knowing full well that the lawyers are going to look for any inconsistency between his testimony during the congressional hearings and his testimony under oath. If they find any inconsistency, you know darn well it's going to be headlines for days. Lawyers, being what they are going to ask Brett Kavanaugh questions like, do you recall ever having done X, Y, and Z? And when his answer is no, I don't recall it, headline is going to be Brett Kavanaugh does not recall having done X, Y, and Z. Unfortunately, litigation is a fundamentally dirty business, and you have to weigh your best case scenario with your worst case scenario. We saw what happened with Nicholas Sandmann's lawsuit against the Washington Post and how that was dismissed. Now, admittedly, it was dismissed on an entirely different basis, not because Nicholas Sandmann failed to prove actual malice against the Washington Post, but because apparently, according to the judgment, and if you want to see a video on that, I'll link it right here. According to the judgment, the articles and statements were either not defamatory or not about Nicholas Sandmann. So that lawsuit was dismissed on an entirely different basis and not because Nicholas Sandmann failed to prove actual malice. But proving actual malice is a high threshold to prove, and the litigation process itself is not fun. And knowing how things are leaked to the media, knowing how the media runs with sound bites to make a point. Brett Kavanaugh, sitting justice of the Supreme Court of the United States, would have to weigh his options. What is the most likely outcome? What is the best case scenario? What is the worst case scenario? And what is going to happen regardless? Partisan politics being what it is in the United States, in Canada, in the world for that matter, you know that there are people who are never going to change their beliefs. And even in the presence of litigation, they're not going to rely on the outcome to change their opinions. They're going to cherry pick through the litigation to pull out tidbits of information, sound bites, clips, whatever, that support the positions that they already hold. So practically speaking, I don't think that even if Brett Kavanaugh filed suit, it would change the minds of anybody. The more probable risk, in my humble opinion, is that in the context of litigation, the media is going to get some sound bite, some clip, some piece of information that's going to allow them to justify their opinions or move the goalposts, run with different headlines, focus on another story that comes out as a result of this litigation, which allows them to continue doing what they're doing. It may be one of those situations where even though he can file a lawsuit, even though there may be a legal basis for doing so, there may be nothing to gain from it except potentially trying to hold the press to some sort of ethical code of conduct, some form of responsibility as relates to their coverage, or it might just be a question of letting the public and not the courts decide as to whether or not what the New York Times is doing is responsible quality journalism. All right, that is your vlog for the day. I hope you enjoyed it. If you like this content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section, share the link with anyone who you think might appreciate this. If you want some Vlog Dog merch, I'll put the link in the pinned comment, and now you know your vlog. Peace out. Booyah!